As we move to the Constitutional Court, where the court's delivering judgment on whether South Africans should automatically lose their citizenship when they acquire the citizenship of another country. We're going to cross live to that right now.
Impugn provision is constitutionally invalid. Section 6(2) of the Act cannot save the impugn provision from unconstitutionality. The court then reflects on international and foreign law surrounding citizenship. There are no specific provisions in international law on dual citizenship, and in accordance with the principle of state sovereignty, each state may make provision for this. In a world of increasing globalization and transnational mobility, permitting dual citizenship is the norm rather than the exception. Many countries expressly provide for a right to dual citizenship, and the constitutions of a number of countries provide that citizenship may be lost only through voluntary renunciation. This, by implication, excludes a loss of citizenship due to acquiring the citizenship of another country. International law generally acknowledges that it is in principle legitimate for a state to wish to protect the special relationship of solidarity, loyalty and good faith between it and its nationals, and the reciprocity of rights and duties which form the bedrock of the bond of nationality. But loyalty has undergone a fundamental change in light of the commonality of global issues, and the loyalty objection to dual citizenship today no longer holds up to the same extent. In sum, then, the court holds that the impugn provision is unconstitutional as it infringes the right to citizenship entrenched in Section 20 of the Constitution, and consequentially other constitutional rights, namely political rights, the right to enter and remain in South Africa, and the right to freedom of trade, occupation and profession. The impugn provision must therefore be struck down. Finally, the court notes that careful consideration was given in the Supreme Court of Appeal regarding the remedy that would grant the most effective relief. That court struck down the offending part of the impugn provision and ordered that the striking down be with immediate effect to take effect from the date of its enactment, which is 6 October 1995. Excuse me. The Supreme Court of Appeal cannot be faulted for the conclusion it reached based upon its unassailable reasoning. The Act came into effect on 6 October 1995 when the interim constitution was still in force. The impugn provision is unconstitutional in terms of the Constitution, but the same is true in respect of the interim constitution. The declaration of invalidity should therefore take effect from the date of the Act's promulgation on 6 October 1995. There is no need for a suspension order, and the department accepted throughout this litigation that in the event of a striking down of the impugn section, such suspension would be unnecessary. And then finally, the DA is entitled to its costs. What remains is for the court to acknowledge the helpful written submissions of the amicus curiae, Dr. Spadija, particularly with regard to international law. The court makes the following order. 1. The order of constitutional invalidity of the Supreme Court of Appeal is confirmed. 2. It is declared that Section 6(1)(a) of the South African Citizenship Act 88 of 1995 is inconsistent with the Constitution and is invalid from its promulgation on 6 October 1995. 3. It is further declared that those citizens who lost their citizenship by operation of Section 6(1)(a) of the South African Citizenship Act 88 of 1995 are deemed not to have lost their citizenship. And 4. The respondents are ordered to pay the applicants' costs in this court, including the costs of 2 counsel were so employed. I hand on the judgment.
As the court pleases.
As the court pleases.
The court adjourns. Thank you.
Please rise. that Constitutional Court ruling handed down, and we will be looking into that, I'm sure, over the next few days.